continue with opening arguments, hearing from Mr. Breite. Whenever you're ready, sir.
Morning, ladies and gentlemen. A young man has been killed. His death, like every senseless death, was tragic. And it is a tragedy for his family and friends. I say this now at the very beginning because it's important that you not think that anything I may say or do in the defense of my client, Courtney Simpson, is meant to suggest that this is anything less than tragic. My defense of Mr. Simpson is not and will never be an attempt to diminish the seriousness of what transpired that night, nor to make less of the pain and suffering that's undeniable in this case. Ladies and gentlemen, we're here for a different purpose. We do not need to decide whether this killing was tragic. We already know that it was. But our purpose, actually your purpose, is very different. It's to decide if the state has proved that my client killed Farron Green. I'm sure we all agree that the prosecutor set forth very serious allegations against my client. And if we simply accepted all of those statements as true, then we would have absolutely no need for this proceeding. But of course, the prosecutor was not a witness. He was not there when this incident took place. And every single thing that he tells you is nothing more than a statement of what he expects or hopes to be proved by his witnesses. And that's an extremely important point. It's extremely important to distinguish between the statements made by a very fine and articulate prosecutor and the actual evidence that he will use in an attempt to prove his case. Evidence, ladies and gentlemen, that you will see will prove absolutely nothing against my client. The prosecutor alleges that my client is a killer, but as you hear the testimony come in, you will find that that is simply not true. As you hear the testimony to support these serious and in fact false charges, what you will find are a mass of critical inconsistencies, glaring omissions, and testimony from witnesses that is simply untrustworthy and unreliable. You will hear from witnesses who have their own motivations for the stories that they've concocted, motivations that have nothing whatsoever to do with the search for the truth as to the charges against my client. As you listen to the testimony of the witnesses produced by the state, ask yourselves about the credibility of these people, the believability of these people, the trustworthiness of these people. Ladies and gentlemen, it's not enough that the state comes forth and tells you that somebody is guilty. That's not enough. In our country, America, the state must do a great deal more than that. And that is why we say that the state has the burden of proving its case beyond a reasonable doubt. This means that each and every one of you must have absolutely no doubt that is based in reason that my client committed the charges against him. That standard, beyond a reasonable doubt, is the foundation of our criminal justice system. In fact, it's not an exaggeration to say that the standard of beyond a reasonable doubt is the bedrock of just about every freedom that we know and enjoy in this country. Without that standard beyond a reasonable doubt, the state would have the awesome power to take away our freedoms without having their allegations, their accusations, subjected to the highest level of scrutiny that is demanded by our system of justice. It is the burden of the prosecutor, and only the prosecutor, to meet that standard of beyond a reasonable doubt. I think we would all agree that any system in which the burden is not placed upon the accuser to prove his accusations would be no system of justice at all. It is entirely the accuser's responsibility to meet that high level. Mr. Simpson is now presumed innocent. That presumption, ladies and gentlemen, is going to stand up against the evidence put before you by the state. You will find that the state's evidence is weak and simply not the type that you can rely upon to convict a young man of such a serious crime. Finally, I want to thank you in advance for the attention that I know you're going to give this case. It's a serious case, obviously, and it's an extremely serious case to my client, Courtney Simpson. I am confident that after you hear all of the evidence, you'll find that not only is there just one reasonable doubt, but there exists many, many reasonable doubts throughout the state's entire case, and that the only appropriate verdict for my client would be a finding of not guilty. Thank you.
Thank you, Mr. Bright. Ladies and gentlemen, jury, we're going to take our morning recess, so you'll be free to grab a cup of coffee, come back. Please be back here by 11:30, 11:35. Okay? No later than 11:35. By this clock, I don't know whether it's accurate or not. Okay? So 15, 20 minutes. Thank you. Please don't discuss the case. You can go right out or grab stuff in the jury room. Thank you.
Well, Scott.